Town Center Place versus Carolyn Lee.
Good morning, Your Honor. Jackie Snyder, Powder. Well, I guess it's afternoon now. For plaintiff.
All right. Miss Lee? Hello.
How you doing?
I'm doing well. All right. What is, this is a termination of tenancy case. Is that
Yes.
correct? All right. Basis for the termination.
The basic habitual late payments.
Pardon?
Habitual late payments.
Welcome back to Trial Truth, where everyday courtroom disputes reveal the complicated realities hiding behind legal paperwork. On today's docket, what initially appears to be a straightforward eviction case quickly transforms into something much more layered. Judge Simpson is faced with a difficult question. Where do you draw the line between enforcing lease agreements and recognizing the struggles of an elderly tenant trying to navigate life on a fixed income? The landlord points to years of chronic late payments. The tenant insists she's trying her best and even arrives with money orders in hand. But in court, intentions alone rarely resolve legal obligations. As this hearing unfolds, you'll hear admissions that raise eyebrows, explanations that invite sympathy, and moments where the judge is forced to balance accountability with compassion. Is this simply a case of repeated financial irresponsibility, or are there deeper issues at play that have contributed to this pattern over the years? That's exactly what Judge Simpson now has to determine. And trust us, this case is about to become far more emotional and complicated than anyone expected.
All right. So what do you have to say about this?
I have 3 money orders. I have $1,800. I tried to give it to her. She wouldn't take it.
Give them to who?
To the landlord. Sarah. I mean, not Sarah. Sarah. She wouldn't take it. They stuck them right back in my door.
Okay. So how much is your monthly rent?
I really couldn't tell you. I really couldn't tell you.
All right.
She just gave me a paper hour ago saying $642.
For your monthly rent?
But the other day, well, a couple of days ago, they gave me, I guess one of the doors saying 644.
Okay, but
I
Miss
can tell you.
Lee, do you understand why you're here?
Yes, I do.
For habitual late payment? Okay. Is there a reason that, and so right now, how much does she owe right now? Do you have that?
$2,627.
$2,600.
$27. But Your Honor, the reason for the habitual late payments is over the past, she's been here for 88 months and up with us 51 times.
Been late. That's not what she told me the other day.
Huh?
She told me I've been late 88 times.
88?
I was 51 times.
Okay. I don't know that either one of those are good, but
I mean, out of 88 months.
out of 88 months. So here, ma'am, Ms. Lee, I would tell the plaintiff that they may need to work out some other type of thing with you. However, the problem that I'm having here is the 1,800 that you have, right, doesn't cover the back balance that you owe, right?
I have been asking these people in the office if they would help me get online.
To do what?
Would help me get online because they got online banking or some kind of thing where your money can come out of your account.
Okay.
They
Oh, that it can
Right.
come out of your account.
Well,
Okay.
just the rent part.
This is where the narrative begins to shift. Up until this point, the landlord's position seems straightforward: repeated late payments, outstanding balances, and years of documented issues. But Ms. Lee introduces another dimension: entirely difficulty managing modern payment systems and a repeated request for assistance that she claims went unanswered. In today's world, automatic withdrawals and resident portals are second nature to many people. But for seniors who aren't technologically comfortable, these systems can become barriers rather than solutions. Legally speaking, the judge still has to address the unpaid balance. However, morally and practically, he appears to be asking whether a preventable situation has spiraled because nobody stepped in to bridge the gap. Could earlier intervention have prevented this courtroom appearance altogether? It's an uncomfortable question because it challenges everyone involved. Responsibility matters, but so does accessibility. And Judge Simpson seems increasingly interested in whether there might be a path forward that preserves housing stability without ignoring the landlord's legitimate concerns.
The 642 starting, I guess, next month. But they
Okay,
told me they can't help me
But
because
here's the problem, Miss Lee.
okay.
Okay. And if that were something that's available, I don't know if it is or not, but if it's something that's available, that's fine. And I would certainly suggest that to the plaintiff. That might cause, but let's say I said, yeah, plaintiff, you got to do that. You got to take it out of your bank account every month to 642. The problem is you're 800. If you pay the 18, you're still like $827 in the hole.
I can make it up by September 1st.
Pardon?
I can make it up by September 1st.
By September's what?
First. We're the 3rd.
All right.
I did call Hawk.
Okay, Miss Lee. You get a check every month, right? Is that
Yes.
okay? How much is your check each month?
I think 2108.
And when does that check normally arrive?
In between the 1st and the 3rd.
Okay, so let me ask you this. Check arrives between the 1st and 3rd. Why haven't you paid your rent?
I had to make up for the other.
Pardon?
I had to make up for the July because
I'm sorry?
I had to make up for July. That's how I got to 18.
You had to make up for July?
Judge Simpson is now drilling into the heart of the issue, not whether Miss Lee wants to pay, but why the rent consistently isn't being paid on time, despite a predictable monthly income. The distinction is critical. Courts often look for patterns, and landlords build termination cases around those patterns. If income arrives regularly, the expectation is that rent the roof over your head becomes the priority expense. Yet Miss Lee's explanation paints a picture many viewers will recognize, juggling obligations until one missed payment snowballs into another. Suddenly, current rent is being used to cover previous rent, creating a cycle that's increasingly difficult to escape. The judge isn't merely interrogating her. He's trying to determine whether this pattern is fixable or destined to repeat indefinitely. What do you think? Should repeated late payments automatically justify eviction, or should judges have broader discretion when elderly tenants demonstrate genuine efforts to catch up? Let us know in the comments, because this balancing act between accountability and compassion is at the center of today's case.
What do you mean by that?
Well, July, I didn't have July's money order neither, so I had to make it for July. So I got 3 money orders now.
Okay, but let me ask it a different way. If you receive a check between the 1st and the 3rd of each month, right?
Yes.
What stopped you from getting your rent paid on time?
No reason. I have other bills too.
What?
I have no reason for that, Judge. I really don't. I just have bills to pay. There's no reason. I try.
Right, that's life. I mean, there are other bills that have to be paid, but Miss Lee, do you have somebody that helps you with your funds?
I used to, but they don't help me. They lie about it. They cheat, steal. Not no more.
Okay, so who was this person that was helping you?
This is one of my friends. Her name is, I hate to say her name.
And
Her name was London, but still.
okay, let me ask you this. What were they supposed to do for
You're
you?
supposed to take my card, go to the post office, get a money order. I called them. They never respond. change the number. I had to get another card. Money come. So,
And so would it be fair to say that there were some months, and counsel help me here, but were there some months you did this and your rent didn't get paid at all?
Right. Money was gone too.
Pardon?
Yeah, money was gone too. That's why.
And this person that was your friend took off with your money?
Yep. And I really hate that, but that's okay. Lord will bless me.
What?
The Lord will bless me.
Now the case takes another unexpected turn. Miss Lee reveals that someone she trusted may have mishandled or outright taken money intended for rent payments. If true, it adds another layer of vulnerability to an already fragile situation. Older adults can unfortunately become targets for exploitation, especially when they rely on others to help manage finances or daily tasks. Judge Simpson's tone noticeably shifts here. Instead of focusing solely on lease violations, he begins exploring Miss Lee's support system, or lack thereof. Who helps her? Who can she trust? And perhaps most importantly, who can ensure that future rent payments actually reach their destination? From the landlord's perspective, explanations don't erase financial losses or litigation expenses. But from the court's perspective, understanding the underlying causes of chronic issues may be essential to crafting a fair resolution. This isn't just about numbers anymore. It's about whether the circumstances suggest an ongoing inability to comply or whether proper support could finally stabilize the situation.
Bless her though, she's gone now.
Okay.
I hate to say that.
Okay, so, and I'm not saying this to embarrass you, Miss Lee. You get your check, and because there are people like this, sometimes I'm like this, where you're going to have difficulty making sure that something's done, right? And that's why what you proposed up here was something where they take it out of your account because you know that you might forget if you have to try to do this on your own.
Right.
Is that fair?
Yes, if I can get that. The only reason why they wouldn't do it because they had a bad check, 2002.
Okay, and so the 3 money orders that you have now, you got, I mean, why do you have 3 more money orders now?
Because like I said, I put them in the night box and the next morning they stuck them in my door. So,
Okay, I hear you. But I'm just saying, so how many times have you tried to give them a money order? Three different times or 2 times, and then you have 1 now?
just 2 times. She said she wanted it all, so we can get the money.
Okay, were you trying to catch up?
Mhm.
I'm not asking because I'm rude. Okay, I'm going to ask you another question, but I'm not trying to be rude or just throw everything out there. Okay, although I can be rude, I'm not trying to be here. How old are you?
I'll be 74 this coming 23rd of August.
Okay, God bless you.
At 74 years old, Miss Lee finds herself standing in housing court defending her right to remain in the place she calls home. Age alone doesn't exempt anyone from contractual obligations. However, it can profoundly shape how judges assess credibility, capacity, and the availability of reasonable alternatives. Judge Simpson appears increasingly aware that this isn't a tenant intentionally disregarding responsibilities. Instead, he sees someone struggling to navigate systems that have evolved around her while dealing with fixed income limitations and alleged betrayals by people she trusted. That doesn't automatically eliminate the landlord's claim, but it does raise a difficult question. Should courts seek solutions before imposing the harsh consequence of displacement? The stakes here extend beyond unpaid balances. For seniors, eviction can have devastating consequences, disrupting healthcare access, community connections, and daily routines that become increasingly important with age. As this hearing continues, the judge seems determined to explore whether intervention remains possible before reaching a final decision.
Counsel, let me ask you this. Well, two things. Is there a program that will automatically take her rent out for your
I
client?
wanted to defer my client.
Yeah. Hello.
There is a resident portal that they can set up, but the problem is that they can cancel it too.
Okay. Okay. No, I get that. But
At this point, I feel like I need guaranteed payment.
ma'am, there is nothing guaranteed in this life. There is nothing guaranteed in this life.
I understand.
So, I mean, the problem is you may want guaranteed payment, but I'm also looking at Miss Lee, who is just trying to make it month to month. And some of the things she admits she can't do herself.
Okay, here's the problem. I just looked at her last research. She makes 3 times most of the people that live at my apartment.
Okay, and I could make 3 to 5 times more, but if I couldn't manage my money, then I still run into a problem, don't I?
Okay, I agree.
There's more of a pattern than the current arrears.
No, I hear you, but
And Your Honor, we've been here 10 times. Honestly.
I'm aware, and I'm trying to. When did you stop giving this friend of yours your card to do your business for you?
Last year, I'll say around about last year. A
When?
couple of months, maybe 5, 6 months ago. And
Okay.
can I say something?
Go ahead.
If all of us seniors, well, I'll say myself, if we go in the office and ask for some help, seem like they would help us if they want their rent money. But they act like they dumbfounded, don't know what to say. They don't want to give us nothing. They don't want to help us with nothing. I go in the office all the time. Can you help me? Can you help me? No, we don't have no account money. No, we don't have no account. Do that make any sense? My bank asked me twice to get their account number so I can have my rent coming out of my checking account. Last year before that, they said no, they don't have an account number. So they just won't help us seniors. That's a shame.
Miss Lee's frustration is unmistakable. She describes repeated attempts to obtain assistance with setting up automatic rent payments, only to encounter what she perceives as indifference. Whether those perceptions perfectly align with reality is difficult to determine from the courtroom record alone. But her testimony highlights a broader issue facing many elderly residents, navigating increasingly digital systems without adequate support. Judge Simpson now finds himself examining not just individual conduct, but institutional responses. Could better communication have helped? Were there available resources that simply weren't accessed? Or are both sides operating within systems ill-equipped to address the needs of aging populations? Housing disputes rarely exist in isolation. They're often connected to healthcare challenges, technological barriers, limited support networks, and economic pressures. By allowing Miss Lee the opportunity to explain these experiences, the judge signals that context matters even when legal obligations remain unchanged. The ultimate outcome is still uncertain, but it's clear this hearing has evolved into something far more nuanced than a routine eviction proceeding.
Let me ask this. Well, first of all, Miss Lee, do you know how to get in there to set up the automatic withdrawal from your account?
I asked this one lady, she said she'll help me because I don't know how to do that stuff.
Okay. So you were going to ask who?
I was going to ask this lady named,
Is this like another one of these friends?
no. She lives in the building. What's her name? Viola Davis.
Who?
Viola Davis. I was going to ask her to help me. She know how to do it.
Okay.
But that's the way she got hers set up.
Pardon?
That's the way she got hers set up. No, I don't understand why the office can't help.
Well, there's a lot of stuff, as I sit up here, I don't understand in the world. So the thing here is Counsel, if she gets herself back to zero and sets this up, are the plaintiffs willing to let that at least roll for a little while to make sure or let her pay that way?
Um, I don't think so, Your Honor. At this point, they've had enough litigation costs and
But she's paying the court costs when she comes here.
yes.
I mean, I've got a 74-year-old woman who admittedly can't manage her money. She's trying.
This may be one of the most revealing moments in the hearing. Judge Simpson openly acknowledges what everyone in the courtroom can see. Miss Lee is trying, but trying isn't always the same as succeeding. The judge isn't excusing the late payments. Rather, he's questioning whether additional support mechanisms could transform a failing situation into a sustainable one. Notice how the discussion shifts toward practical solutions, direct withdrawals, assistance programs, and intervention from outside agencies. That's significant. Courts often function as places of judgment, but occasionally they become venues for problem solving. The judge appears determined to exhaust those possibilities before authorizing a result that could permanently alter Miss Lee's living circumstances. Should housing courts focus more heavily on connecting vulnerable tenants with resources before eviction becomes inevitable? Or does that expectation place an unfair burden on landlords who have already fulfilled their obligations? It's another difficult question with no universally satisfying answer, and exactly the type of issue that makes these proceedings so compelling to watch.
And it would be different if we had someone that would intervene and help her manage her money. But hear me out. If you're asking for it just to be a direct deposit and that to be the simple thing, then the money has to be in there for it to be directly deposited. So
She gets what is your check at the beginning of the month? Social Security or
Social Security.
so she gets a Social Security check at the beginning of the month.
mhm.
They can't direct the money out of my account, out of my checking account. Oh, I'm sorry.
Just
Well, whether people are trying to be or not, sometimes they are. Because, I mean, the problem here is this. I think that there's funding out there for somebody of her maturity that we could maybe fill the gap. So she's got the 18. Get the gap filled so that she's back to zero. And then set up a withdrawal from her account. And so assume for the sake of argument that could happen. What would be wrong with that?
I guess for the sake of argument, the only concern would be the fact that the money could be taken out before the direct deposit goes through.
What do you mean? If the direct deposit is set for, say, the 5th, because I assume when she's saying her check arrives between the first and the third, it's going to depend on whether or not there's a weekend, what there's there is there. So if it's set to, let's say, to come out on the 5th,
Mhm.
and all of that were to work out, what would be the harm?
It would be something I need to discuss with my client here.
Well, you got time. I'm going to pass it. Miss Lee, have a seat. And I just suggest that, when you go out there and think about it, maybe one of the things that should enter your mind is, with the grace of God, maybe we'd all get to her age. And at her age, we would just have to pray that we would have our faculties in a position where we can just try to take care of business. Have a seat. I'll call it back up.
This is a pivotal procedural moment. Rather than rushing toward an immediate ruling, Judge Simpson effectively presses pause. He's encouraging discussion, inviting reflection, and signaling that compromise remains possible. The underlying message seems clear. If a realistic path toward future compliance exists, perhaps it deserves consideration. From the landlord's perspective, hesitation may feel frustrating after years of documented issues and repeated court appearances. From Miss Lee's perspective, however, this pause represents an opportunity, perhaps her final opportunity, to demonstrate that circumstances can improve. Courtroom outcomes aren't always determined solely by who's technically right or wrong. Sometimes they're shaped by whether judges believe future success is realistically achievable. Judge Simpson appears to be weighing exactly that possibility. Can Miss Lee maintain timely payments with appropriate support structures in place? Or are the past patterns simply too entrenched to overcome? The answer to that question may ultimately determine whether she keeps her housing.
Courthouse case, Town Center Place versus Sigrid Melvin. Thank you, sir, for helping. Hello.
My name is Sigrid Melvin.
Okay.
I live in federal housing, low income. And she is our landlord. And according to her, I have plants on my balcony. I've been there since 2006. Some of my plants are tomatoes and spices and that. And the balcony is part of my apartment. So it's up to me to put on the balcony what I like. But at this time, since I would like more time to comply. So I'm able to meet with my attorney regarding the removal of plants from my balcony. I am willing to work with my attorney to resolve the issue. And I had the plants since 2006. And I even have 40 garden boxes controlled with God Growing Hope. I helped install that so that my neighbor and I will have fresh fruit and vegetables. So this is
Okay. Wonderful. Thank you for that. Thank you for that.
okay.
Okay. Can you hear me okay? Or let's give you some headphones so that you can hear me, okay?
Sometimes it works, sometimes it doesn't.
Okay. These are pretty good.
Yeah. Oh, this way? Oh, okay.
Is that better?
Oh, yeah, I can hear you now.
Okay.
Oh, what?
Okay. All right. So what is the claim in this case? Uh-oh.
This is all the
Did you
noise.
broke it, Alan?
Yeah, I lost you.
Is that good?
Yeah.
Test.
Okay,
You good?
yeah.
Okay.
Well, I only got two hands.
Geez, I'm kidding. What is the claim in this case?
Here,
I'm assuming
I'm
plan.
asking, the plan,
Hold on. I'm asking them what their claim against you is, okay? Okay, go ahead.
All right, Your Honor, this is termination of tenancy matter for excessive items stored on her balcony, potted plants, light hangings, etc. She was involved initially.
As one emotionally charged housing dispute pauses, another immediately steps into the spotlight. This time, the issue isn't late payments, it's plants. Lots of plants. What initially sounds almost humorous quickly reveals another serious conflict involving lease compliance, quality of life concerns, and differing perspectives about what constitutes reasonable use of residential space. Miss Melvin views her gardening efforts as sources of nourishment, joy, and community engagement. Management views them as violations involving excessive storage and maintenance concerns. Once again, Judge Simpson finds himself navigating competing narratives where neither side sees itself as unreasonable. Cases like these remind us that housing court often addresses deeply personal matters. Balconies aren't merely architectural features, they're extensions of home. For some residents, particularly seniors, tending to plants may represent independence, routine, and purpose. Yet lease agreements establish boundaries designed to ensure consistency and safety throughout shared living environments. As this case unfolds, those competing values are destined to collide.
Advised but in writing on 2 or 3 occasions. She also has several plant boxes that have piled over in the courtyard and refuses to clean them up. We had meetings about it with her and her attorney.
Who's her attorney?
At the time, it was,
I don't have an attorney right now. I'm working with legal aid.
but they have not filed an appearance or contacted us since the tenant meeting that we had back in June.
Okay, so there was a tenant meeting in July.
Yes.
They haven't contacted you back.
Yes.
Okay, so, ma'am, do you think that legal services is representing you?
Well, they did in a couple other cases.
Okay, so when's the last time you talked with them?
Yesterday.
Okay, so yesterday, what'd they say to you?
Nothing.
Oh,
No, because you go there and they drop off all these legal papers and then they call you and send you a letter. So you don't have a one-on-one interview.
So you went there to drop off some stuff and you haven't heard back from them.
Right. So
Oh.
that's why I need more time.
And after we filed the case, we did inform them that we were filing. So they were aware.
Okay, but so do you have a photo? I mean, she's describing to me plant boxes, but I mean, is there? Okay, my eyes, I'm old.
That's what you have on a balcony.
I know, ma'am. I'm just, okay, hold on, though. Let me just see what we're talking about.
She also has a subsequent notice to quit that hasn't become due yet, but it will be an issue soon.
Can I go back there and get my pictures?
Hold on a second.
Okay.
So I'm just trying to get this second picture. These are on the ground level. She's on the second level.
In the courtyard, yeah.
Okay.
That's her plant box, and then
We're 11th floor building.
you see this village around it and behind it here.
Okay.
Judge Simpson now transitions from abstract allegations to concrete evidence. Pictures enter the discussion, allowing everyone to move beyond general descriptions toward a more objective assessment of the situation. It's a reminder that documentation often shapes courtroom outcomes far more than emotion alone. Miss Melvin clearly takes pride in her gardening activities. She references tomatoes, spices, roses, and years of maintaining these arrangements without apparent issue. Management, meanwhile, emphasizes policy violations and the importance of uniform standards within federally supported housing environments. Neither perspective exists in a vacuum. Residents seek autonomy within their homes. Property managers seek consistency and compliance across entire communities. When those priorities clash, judges are tasked with determining whether accommodations are appropriate or whether rules must prevail. One thing is becoming increasingly evident throughout today's proceedings. Judge Simpson isn't interested in snap judgments. He wants details, He wants context. And perhaps most importantly, he wants to understand whether practical resolutions remain available before resorting to more severe outcomes.
Right. Not till my 3 o'clock. What time am I at now? Time just stopped. Huh?
1:20.
When were those pictures taken?
It's gonna be in July. I can take better ones. I mean,
The condition's still the same, Your Honor.
All right. So, ma'am, the pots and boxes and things that are on your balcony, you don't want to move them? Is that
I have tomatoes, sunflowers, even my cable TV is in a box so I can watch TV. I've been there since 2006.
I got you, but you got cable TV out there?
Yeah. Well, it's on the antenna. It's in a pot on the balcony to stabilize it. So I can watch TV.
Okay.
And those other plots, they have tomatoes in it. They have my spices in it. And one has okra grown. And there's 3 rose bushes that I got when I had my birthday, Easter, and Mother's Day. And usually when the flowers are done, I would put them in the front yard of the building so the roses would grow the next year. But due to this management team, I'm not allowed or do anything that really
Okay.
helpful.
So I see that there are a number of pots out there. All right. I'm not going to go through what's in them. I'm just at this.
Okay.
How many is she allowed to have any out there?
She's allowed to have 5.
5.
And no indoor furniture or accessories are permitted. No bird feeders or anything that would attract rodents. It's supposed to be clean and sanitary, orderly, trash-free, clear of junk, debris, unsightly items.
Okay.
And Your Honor, we have another termination notice to her for rodents.
For what?
For rodents, Your Honor.
Just when it seems this dispute centers exclusively around balcony gardens, a new allegation dramatically raises the stakes: rodents. Management suggests that conditions associated with Miss Melvin's property usage may have contributed to pest concerns. Miss Melvin strongly disputes that characterization, arguing that mice issues extend beyond her individual unit. Allegations involving health and sanitation often carry significant weight in housing proceedings because they potentially affect entire residential communities. Yet, proving causation can be extraordinarily difficult. Are the rodents connected to gardening practices, building-wide conditions, something else entirely? These questions matter because consequences may hinge upon the answers. Meanwhile, Miss Melvin passionately defends both her character and her living habits, framing herself not as a problematic tenant but as someone unfairly targeted by management. The emotional undercurrents are impossible to ignore. Beneath the legal terminology lie deeper themes of dignity, independence, and the fear of losing control over one's environment.
What?
Rodents.
Mhm.
Like mice and
Yeah.
Oh, yeah. Well, that's my next court appearance here. For some reason, I'm the only one in the building that has mice. And the way I discovered them, I was cleaning my shelves. And there was a lot of black stuff around. Then I cleaned the next shelf and on the bottom. I even removed the refrigerator to find all that stuff. We have pest control in the building that comes every Friday for the last 2 years. So the last time the guy came, he didn't even have to trap. for the catching the mouse. So now they blame me for bringing the mice in, all the way up to the 3rd floor. But I talked to some of the neighbors, they even had them up on the 11th floor. So this is just a reason for them trying to convict me, which they've been trying to do since they took over. I have a court case here. Oh,
Hold on.
and plus, when I had fire in my apartment, they didn't send maintenance. When I had the water leak from the 5th floor down, they didn't come and soak up the water. They didn't help me at all. I'm sorry.
No, it's okay. It's okay. So I mean, the case isn't before me, but they're. I'm going to assume they're not her mice, right?
No.
Well,
So,
But when you have.
may I answer that?
well, I'm really hoping they're not your mice. You
No.
can answer it, but
No,
I'm just.
because I like to eat and I can't have food in the apartment and you can't walk at nighttime going to the bathroom. So you might step on a mice, but they're not sending anybody up to clean up the mess. I had to do it all myself. I'm 83 years old.
Okay.
Miss Melvin's testimony becomes increasingly emotional as she describes what daily life inside the building has allegedly looked like from her perspective. What stands out here isn't just the disagreement over responsibility, it's the profound sense of frustration and helplessness she's expressing. She feels unheard, she feels blamed, and she feels like she's been left to handle problems on her own, despite her age and circumstances. From a legal standpoint, however, Judge Simpson must separate feelings from facts. Housing courts aren't designed to determine who is the nicest person in the building. They're tasked with evaluating whether lease violations occurred and whether those violations justify the requested remedy. That distinction can be difficult to accept when litigants are discussing deeply personal experiences. At the same time, this exchange highlights why housing cases often become emotionally charged. For tenants, these proceedings aren't simply about contracts. They're about home, security, dignity, and the ability to continue living independently. Those emotional realities don't decide cases, but they undeniably shape the atmosphere in which decisions are made.
When is that case going to wonderfully grace my court doorstep?
The September 15th is the date up for the termination, for the notice to quit.
That's your date, and then you got to get a court date after this. So we're gonna. Okay.
So I'm just making court aware of it as.
Okay.
I do live in federal housing.
You're right. I understand, ma'am.
Okay.
I get that part of it. I'm just trying to.
Understand.
Okay, so let me ask you this. Are there things growing in more than 5 pots?
Yeah. Okay.
Like food.
If they want me to move the other parts, I like to be paid off because it costs me my money.
You want to repay what?
I had to pay for all the parts on that.
I think. Right.
So on the low income on Social Security, you don't get much pleasure for anything else except planting foods and that. She won't even let us have to click it to the TV in the community room. That's how mean she is, because somebody might steal it.
At this stage, Judge Simpson repeatedly attempts to redirect the discussion back toward legally relevant issues. Miss Melvin, meanwhile, continues painting a broader picture of deteriorating relationships within the community. From television remote controls to social activities among residents, she describes an environment that she believes has fundamentally changed for the worse. And here's the challenge. People rarely walk into court carrying only the issue listed on the complaint. They arrive carrying months, sometimes years of grievances, disappointments, and unresolved tensions. What begins as a dispute about balcony plants can quickly evolve into a referendum on management style, community culture, and perceived fairness. But the judge's role remains clear. He has to identify what actually matters to the case before him. Are there too many pots? Are there lease violations? Is there a reasonable opportunity for compliance? Those questions, not neighborhood politics, will ultimately guide the court's decision. Still, it's impossible to ignore the loneliness and isolation that occasionally surface beneath Miss Melvin's testimony.
Your Honor.
What?
Oh, but
You can't have the clicker. Okay.
Yeah.
I have to.
We're 170 seniors in that building. And that would be nice. We can get together and socialize again, like before we did with COVID. We had a happy home. We were baking and cooking and this and helping each other out. Now is everybody stays in their apartment. They don't even want to come out.
Okay.
Oh, and she has $5,000.
Your Honor.
We had a survey coming from Harvard University. They gave us $25 gift card. Plus, at the end, they gave us the residence council $5,000. And she's in control of it. She isn't even a resident.
Objection.
I might have got this to do it all the way up.
Objection.
I don't know what
I don't either. Your Honor.
I do,
No,
but
it's not relevant to this case here.
that's true.
Might not be relevant to the case, but the good Lord is listening. Jesus said, what you have done unto one of mine, and given a water won't go by unrewarded. But whoa, if you hurt one of my children. So it's up to the Lord.
He did say that. All right. So you don't want to move any of the pots off of the balcony?
Well, it's my food.
Okay.
And like those 3 roses, they're going to die pretty soon. They're going to be off the balcony.
Right.
Because the gardening is a steady process. You know, you go, come and go.
I know. I hear you. Okay. So what about the ones that are on the ground? Can they move those out?
Well, then I really, it's a Michigan cactus. So it stays in the ground.
A Michigan cactus?
Yes, Michigan cactus. But one of my friends, Navy veteran, has them in his driveway. So I couldn't believe that. What do you mean Michigan cactus? So he bought me that and I put them in the bed. Because nobody is right on the brick wall. It's not like in the middle of the part where the benches are on that. It's on the edge of the building. The only one that comes there is a rabbit.
The conversation now narrows to practical realities. Judge Simpson asks direct questions about whether Miss Melvin is willing to remove certain items. Her answers reveal reluctance, but not outright defiance. She explains the sentimental value attached to some plants and the practical purpose behind others. What becomes increasingly apparent is that compromise may exist, but neither side appears entirely comfortable embracing it. Management wants compliance. Miss Melvin wants acknowledgement that these items matter to her and represent more than simple decorations. Should housing providers exercise greater flexibility when elderly residents develop attachments to activities that improve their quality of life? Or do exceptions inevitably create inconsistency and enforcement problems for everyone else in the community? That's the tension playing out here. And Judge Simpson seems determined to avoid unnecessary escalation if a middle ground remains available. Rather than rushing toward a punitive outcome, he continues exploring whether cooperation might accomplish what litigation cannot.
Okay. So you don't want to move any of those things?
Well, not really, but I'm 83, so I guess I don't have that many years to grow. But if they're going to give me some money, I'm willing to move it or have it moved. Oh, that's right. Also, I need to get paid for the patio bricks they took out. So when the water runs, the dirt comes down. You know, they haven't been nice to me.
Okay.
So you want to adjourn it till I get an attorney, then we can do it all over again. Sorry about
No, and I think that's what I'm going to do with this one is I'm going to put it out to the 29th. I don't think. Yeah. But here's what I'm going to do. I'm going to adjourn it. Is that your last one, Council? Or do we have
I have to
more elderly
talk with
coming?
Miss-
What?
I have to talk to Miss Lee,
Right.
or, to my client about Miss Lee.
But
But other than that, yes.
that's it? Okay. So, ma'am, here's what I'm going to do. Okay. I never thought I'd say I was glad to see you.
Oh,
Oh,
Ever. Well, I mean, welcome. That's not the way to greet people, is it?
no.
Okay, Miss Bauer.
Yes.
One, maybe two things before you get to the cases that you're here on.
Okay.
All right. This is Miss Melvin. Miss Melvin has, and I'm just going to give it. She brought some papers to legal service.
Okay.
All right, and I guess there's been a meeting regarding the plant or the pots that are on her balcony,
Okay.
which she's growing things in.
Okay.
All right, well, vegetables in. Just very clear. So she doesn't necessarily want to move them, but she was waiting for somebody to contact her from, rightly or wrongly, she thinks that
legal aid.
legal aid. No, I got you.
Oh.
I can look up and see if somebody's been assigned to the case.
Okay, but here's what I'm going to do. I'm going to adjourn her case out to the 29th.
Okay.
Okay. And that's my next day is August 29th. At what time? 1 p.m.?
Yes.
Okay. So I'm going to set your case for August 29th, 2025 at 1 p.m. Miss Bauer's going to look up to see if anybody's tried to reach out to you on the case.
Okay.
And then we'll come back and we'll figure out what we're going to do on your case.
Thank you very much.
All right. Thank you.
God bless you.
Thank you, Mayor.
It does.
Judge Simpson's handling of Miss Melvin's matter reflects a consistent theme throughout today's proceedings: patience. Rather than treating elderly litigants as inconveniences on a crowded docket, he repeatedly attempts to understand circumstances, identify available resources, and preserve opportunities for meaningful participation in the process. That doesn't mean outcomes will necessarily favor the tenants. Courts still enforce laws and contractual obligations, but it does mean that the path toward those outcomes can involve empathy, explanation, and procedural fairness. As one case temporarily concludes, attention shifts back to Miss Lee, the tenant facing termination proceedings tied to years of habitual late payments. Unlike the gardening dispute, this matter directly threatens housing stability through financial non-compliance. Yet even here, Judge Simpson seems reluctant to reduce a complex human situation into a simple ledger sheet. The question remains: can a realistic support structure prevent future problems, or has the relationship between landlord and tenant deteriorated beyond repair?
Okay, you're going to go talk on Lee.
Yes.
And Miss Bauer is here. So I'll put it in my own terms. Miss Lee, which she has said, has problems managing her funds. She gets her check at the beginning of the month. She's brought here on a termination with chronic late payments. She has $1,800 currently with her. She has $1,800 in money orders, basically, that she wants to pay to the landlord. That would leave about, I think, when I calculate, about an $850 gap or thereabouts. I'm thinking that there's a funding out there that may be able to close that gap for her. Those that skip or for a senior.
What is the age of her?
Her age?
Uh-huh.
Enough.
Okay.
All right. So I already asked.
Okay.
So if that could get closed, and then what she wants to do is somehow in the portal there can be an automatic withdrawal from her account. Okay.
Mhm.
And she wants to do that. She's going to have a friend help her, which is part of the problem here. She had a friend helping her who, according to Miss Lee, may run off with some money, which is how she's where she is.
Mhm.
All right. But she's got enough to get herself back on track.
Okay.
Plaintiff may or may not be willing, but is a bit reluctant to do that because of the payment history in the past. I had passed the matter for them to go talk to see if there's anything that we could do. But the grand plan that I have in my mind is that. But
And that is Ms. Lee, you said?
Miss
And
Lee,
what's her
she's
first name? Carolyn.
Carolyn Lee. She's back next to Miss Melvin. All right, but they're going to go talk, and then I'm going to call them back up.
Judge Simpson essentially presents a roadmap for avoiding eviction. The strategy is straightforward in theory. Close the outstanding financial gap, establish automatic payment mechanisms, and connect Miss Lee with individuals or organizations capable of providing ongoing support. But theory and reality don't always align. The judge openly acknowledges the landlord's frustration. Years of late payments create legitimate concerns about future reliability. Yet he also recognizes Miss Lee's willingness to pay and apparent desire to maintain housing stability. In many ways, this becomes a test of whether systems designed to help vulnerable populations can intervene effectively before legal consequences become irreversible. One aspect of this case that's particularly striking is how often everyone involved appears to agree on the underlying problem while disagreeing about the appropriate solution. Miss Lee needs assistance. The debate centers around what form that assistance should take and whether enough trust remains to justify another chance.
What are we doing on Miss Lee? Come on now. Court calls the case Town Center Place versus Carolyn Lee. Ms. Lee?
Your Honor, I spoke with Miss Lee. It sounds like she has maybe connected with call in our office. I'm going to send an email through to see if somebody can be assigned to help her connect with skipped funds.
Okay.
I can't make any guarantees because the decision makers are not in the office today, but I can do that.
In terms of whether somebody can help her?
Yeah, whether
or-
our office can
Okay, but
assign the
can you then at least give her if you guys can't, can you give her the number, call for the skip funds?
I told her to contact Housing Bureau for Seniors. Yeah, I believe that they are an entity that can refer
Okay.
for skip.
You got that, Miss Lee?
Yeah, I talked to Hawk too. Right now, already at one.
Okay.
Yeah.
So, all right. So now my question is, what are you guys willing to do?
So our position of auto pay is that from what we recall, we have to look through the ledger and the systems being exact and give you exact dates. She's attempted it in the past and it has not been successful. So
Attempted what?
auto pay.
I have.
That is what my
Maybe that's the right
management is
person?
recalling it. We're gonna have to look through the system to be sure. But it has not been successful. We are open to discussing the opportunity of maybe a payee or some third party that could help her pay. That is like
The landlord's representative introduces an important complication. Attempts at automatic payments may have already failed in the past. If true, that history naturally fuels skepticism regarding proposals currently under discussion. This illustrates one of the most difficult realities judges confront. Hope for future improvement must be balanced against evidence from the past. Optimism alone doesn't guarantee compliance. Yet prior failures don't automatically eliminate the possibility of eventual success. Judge Simpson appears unwilling to dismiss either perspective. Instead, he continues probing for alternatives, including third-party assistance and external support services. His approach suggests that before imposing severe consequences, every reasonable avenue deserves exploration. For viewers watching at home, this raises another compelling question. At what point does repeated noncompliance outweigh compassionate considerations? Is there a numerical threshold? 5 missed payments? 10? 50? Or should every case continue to be evaluated individually? Housing law may involve rules, but applying those rules often requires profoundly human judgment.
Well, a third-party payee, I don't. All right.
I tried that before and they would not give me my money.
I know, because we just went through that.
Your Honor, that was
Go ahead.
a friend. I'm talking about maybe.
I'm talking about B and B.
Your Honor, are there social workers at this? There are not. Okay.
This might be part of the problem,
Exactly, Your Honor.
because I think I've had two mature women up here who I don't say have issues, but have their preferences in life and maybe are entitled to that given the number of years they grace this planet. And there may have to be some folks that help talk through some of these things, because it sounds to me like a lot more is going on than even what is coming before me. So what I'm going to do is I'm going to adjourn this to August 29th, my next available date, 2025
Well, yeah.
at 1 p.m. So she's going to do that part. You're going to investigate the ledger, try to figure that out. You've had, and I think what she's indicating, you've had B&B as your third party payee before.
Yes.
Okay. That you can stop right there. And that didn't work for you. Okay. So that's what she's indicating. It's not just a friend. She's had this third party.
Well, and I'm indicating at this point, we'll investigate, we'll get you numbers and everything else that we believe, but our position is a third party payee that would be responsible for it.
Pardon?
Our position is that at this point, a third party payee that would be responsible for paying her rent and helping her with that would be our preference if she were to stay. That's our positioning.
Okay. That's fine. And I guess if it won't work out, we can go to trial. But I don't think you really want to go to trial with a 74-year-old lady who just wants to pay her rent, but may not be capable of doing so. But that will be up to you and your decision. We'll see you.
As today's proceedings come to a close, Judge Simpson stops short of delivering an immediate final ruling. Instead, he chooses adjournment, preserving an opportunity for further investigation, resource coordination, and meaningful discussion between the parties involved. Across both cases, several themes have emerged. Housing disputes often extend beyond unpaid balances or lease provisions. They intersect with aging, technology, community support, financial vulnerability, and the difficult balance between compassion and accountability. Judge Simpson's approach throughout these hearings emphasized problem-solving alongside legal analysis. He acknowledged landlord concerns while also recognizing the humanity of tenants struggling with circumstances that may not fit neatly within standard procedures. Whether future hearings ultimately result in continued tenancy or termination remains to be seen. What today's docket unquestionably demonstrates is that behind every case number lies a human story, one filled with fear, frustration, resilience, and hope. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.